All right. Hi, everyone. This is Curt,
And Brad Pinsky.
and we're here for another edition of Fire Law Roundup for November 24th of 2025. Brad, go ahead.
Well, it is Thanksgiving week, so let's talk turkey. Um, although I don't have a case that has anything to do with Thanksgiving yet, but I guarantee we will. But first, before we get into our cases, Curt, you and I should. We haven't talked about it. Everybody should look and I'm going to give my, for the first time, sort of thoughts on this. But Curt and I had the chance to interview the a case with the expert with Gary Ludwig and the attorney Michael Gallagher. This was a $31.5 million jury verdict against two chiefs and their fire departments or municipalities for a line of duty death. And I don't want to rehash it, right? But I do want to share some thoughts and get your thoughts with
Yeah, I
this.
think that's worthwhile. Yeah, I mean, we put it out Friday, so it's relatively new. Today's Monday, at least as we're recording this, but
Yes.
Friday we did it, and I'm still processing everything that we talked about. But it's a really important case. It's out of Illinois. The firefighter was from Sterling. The Sterling Fire Department. That's the one that he was killed in the line of duty, and the lawsuit was against the Rock Falls Fire Department. So he had a mutual aid issue there. Go ahead, Brad.
No, yeah, and so there's so much. Where do I start? Well, I want to start with one of my conclusions and then some of the in-depth part. So one of my conclusions, I said this to him, and I think you and I agree. I said, listen, the plaintiff's attorney, you're a very good attorney. He
Yes.
picked a great
No,
jury.
no doubt about it. He had a phenomenal jury.
Oh,
Absolutely.
but not out of happenstance. He
Yeah.
picked it,
Yeah.
right? And
Yeah.
he shared. I thought this was brilliant. He who he wanted on it. He wanted women,
Yeah.
right? Because they'd be more sympathetic. And he wanted like people like union workers, contractors, electricians who were used to standards and realized you adhere to the standard. That
Mhm.
was brilliant.
Yeah.
So he gets the jury mindset, but I don't think he should have won. On a
I think we
legal
both
matter.
agree, and I think he sensed that. He
Oh,
actually
yeah, he
sensed that.
did.
He said, you know, um, but that's one of the reasons why I wanted to let him get his whole story out.
Great way
And
to do it.
again, hats off to him. I think if anything, the lesson to firefighters is this is what you need to be prepared to handle if you
Yep.
make a decision or you make some choices. And another thing, I was thinking about this morning just as I was kind of getting ready for this, and I wasn't thinking we're going to talk about it, but um we're called upon to make split second decisions, okay? And there's life and death in the balance, or people's homes being destroyed, or property being damaged, and so on. So there's big boy consequences with what we do, okay? um Maybe, and I think that's one of the reasons why we have immunity protection. But um, some of the decisions we make are not in the moment. They're decisions on things like staffing. They're things like policy. They're things like what training should we emphasize. And those are not in the immediate. And maybe those are the types of things, maybe in the immediate types of concerns, we should have some flexibility. We should have some immunity protection. Okay. But when it comes to those things that, how much we're going to spend on training, or what are we going to train on, or, or
Yep.
are we going to have a policy, and then are we going to make sure the folks follow it? So how are we going to make sure people are following it, and all that? Those are not in the moment.
Right.
Those are things that the organization needs to sit back and say, and I think that from that perspective, it's almost like maybe there's a need for us to, or not us, but for the legislature that are granting immunity to give us the kind of immunity protection we need for emergency decision making. But
Yep.
some of these other things, it's where the chips fall.
Well, and to your example, so one of the things, and people really better pay attention to this, which is why I think everyone should watch our interview. But one of the things that they got hung on that the plaintiff's attorney said swayed the jury, intended to sway the jury, was you didn't train, right? You're before the moment. There, you didn't train in May days, you didn't train in PAR. There's certain things you didn't train in, and they use that as a basis for saying you were wanton willful, you were reckless, you had a conscious disregard for the safety of others. But they focused on the chiefs not training on May days. And I thought, well, yeah, I guess that's part of it. They said they trained 5 times. Now, listen, training on a May day is
But,
not that hard.
but
I
it
agree
was it
with
was
you.
five times in 20 years.
Right. Right.
But, so I think that's the other component. If you were trained 5 times this year, I think it'd be
Oh,
hard to say you didn't train enough.
right. But that, to your point, is right. That's stuff you can prepare for to you
Exactly.
practice it.
Exactly.
PAR report should be a policy. Every 5 minutes or so, there'll be a PAR report, or after
Not 5 minutes,
Mayday,
not 5 minutes,
whatever it
not
is. I
five
don't
minutes.
care. But
Yeah, at some point, 20 minutes or whatever, or
right.
certainly a change in conditions, such as we're doing a tactical withdrawal,
Yes.
or any sort of a mayday, any sort of a report that someone's got partial collapse or anything of that nature.
Yep. And by the way, I used to do them every 5 minutes when
Oh
I
my
had
God.
Well, I'll tell you why. When I had exacerbated situations, if I've got
Yeah.
active
Yeah.
fire above them, and they're working in a dangerous environment that could be rapidly changing, I would do the every 5 minute PAR. Yeah. In a
Yeah.
normal, one
Yeah, no,
bedroom, whatever, who cares?
yeah.
Right.
Well, we should be doing them, but it's just that, and we've got to become like you're not going to successfully do a par in an expeditious manner if you only do it once or twice a year.
Right.
And that's a problem. And we don't want to be doing them unnecessarily. But when I was a safety officer in Providence, I had to investigate a number of maydays, number of problems, and we had PARs, we call them roll calls, that took like 8, 10, 12 minutes.
Oh, God. Okay.
To
Yeah. Okay.
complete. No.
Yeah.
Because people are interrupting it. Fire alarm is interrupting it.
Oh,
And
okay.
that's
Yeah.
the real life. That's the reality. That is the reality. So we've got to figure out, we got to practice it, folks, and we got to be you got to get it done in 60 to 90 seconds, 2 minutes tops. You should not
Right.
be spending 10. And there was one in particular, it took over 15 minutes to complete it.
They didn't just give you making progress, Chief.
No, we had a firefighter. We ended up doing CPR on him and got him
Oh,
out of the
shit.
basement. It was a basement,
Oh, yeah.
but bottom line is it took 15 minutes to complete the par
Oh, wow.
because
Wow.
it kept getting into, and that's what I mean. You have
Oh,
to,
okay.
and we're a good fire department,
Yeah.
a really good fire department. So it's not a question of that, but it's a question of somebody saying, I need more hose, give me more pressure. Hey, take a line over here, and interrupting the par with all these operational types of things,
Right.
and then fire alarm making notifications and all of that.
Yeah.
So, but you got to practice it.
And that's, to your point, something that could be done in advance, right? So practicing Maydays, huge, practicing PARs, but I'll give you the biggest takeaway I took. So when everyone listens to this, as you should, I hope you will, they kept focusing on the NFPA standards.
Mm-hmm.
And they established without objection, I think the defense attorney maybe made some tactical choices that I would have made, but did a number of things that I think were a huge issue, like no expert witness. I don't care what the plaintiff's attorney says. There was a lot of expert witness that could have helped out and presented a different side. And if you only present one side of the story, of course, that's the way the jury's going to go. But the NFPA standards were used against him. And the plaintiff's attorney even believes, because he's not a fire service attorney by his own admission, he learned all this, kudos to him, kind of on the job, and he used his expert properly. But to say that, and I don't know if you and I are going to agree or disagree on this, I'm interested, to say that NFPA is the standard for every fire department, I disagree with.
I agree too.
A standard. Right?
Well, it is, but here's I think the way I characterize it. It is evidence of the standard of care. It is not the standard of care.
Perfect.
And another way to say that, he said it in the interview. He said it's not negligence per se to violate it, but it's evidence of what the reasonably prudent fire chief would do, what the reasonably prudent fire. Right. It's evidence.
Right.
Okay. And that's it. It's like, and also OSHA standards are evidence of what the reasonably prudent fire department would do, because the reasonably prudent fire department would not ignore an OSHA standard. It would not ignore an NFPA. Now, okay, if you've considered it and you're unable to comply, but you have a plan for complying, and this
is where I'm going. Keep going.
Okay, well, that's, I think, where fire departments that there may be certain parts of NFPA 1500 that you can't comply with. And you know what? We're actually using the wrong term here, 1500. It's now 1550.
Yeah.
They gotta, just another, the shiny object we got to chase around the universe here. But bottom line is, we've got to show that we've got a plan to do it,
So
and staffing may be one, that look, we just can't, but our plan is over the next 3 to 4 years, we're going to improve it. Or, we don't have this particular capability, but we're going to be developing it.
right. And just as a guess, thousands of pages of the NFPA, right?
Mhm.
So this guy says, well, I pulled out the most, inexplorable, you can't avoid these, the most primary, that everybody would agree on.
They were. I think his 6 points, they came up with, they distilled it down to six
Right.
things that.
But for the NFPA, but here's the thing. That's a nice thing to say, but until you've read the NFPA, there's no survey of firefighters that say we've all read the entire NFPA and these are things we agree are the six most important, right? So
No.
to me, what the solution is, which everybody should take away, you should have a policy of the department, because that would override if you're not in an NFPA required state, which says we have reviewed the NFPA, we have adopted what we could, we have not adopted the others, and this is what this is what we decide to implement, so that the NFPA that you didn't incorporate can't be used against you. This is, I won't get off tangent, this is not so different than Lairdsville in 2002, where the fire chief went to jail for not being aware of the NFPA, not for not complying with it, not for being aware of the NFPA 1402 or 3 for acquired structures, right? To me, if we had a policy, if a department implements a policy that says we've reviewed it, we've implemented what we can, we haven't what we couldn't, maybe that wouldn't be used against you in the same way.
I think so. And I think, again, kind of getting to the same thing. I think we're saying the same thing, but maybe a little differently, is that you have an NFPA 1550 compliance plan.
Yep.
And that we're going to comply with this. We can't comply with that, but here's our plan for getting there. Okay. And we can't comply with this, and here's our plan for getting there.
Yep.
And what you don't want to do is just say, we're not going to bother with this one,
Right.
Because that's where you're going to get yourself in trouble.
And I would label, and I label the NFPA as a best practice. And the reason I like to say, unless you adopt it, right? And a lot of it should be adopted. I'm not anti-NFPA in any way, but or any longer maybe since meeting you. But to me, NFPA in many respects is a goal, not in truck manufacturers.
No, I agree. I agree.
But it's a goal. And so if you have
no
a policy,
one's 100% compliant with it.
Right.
Okay.
I don't care what ISO 1 you are.
That's what the fire district's attorney, the fire department's attorney should have raised, that no one is 100%. He should have put, Gary Ludwig as the expert on the stand and said, are you aware of any fire department that is 100% compliant with NFPA 1500? Name one, just one.
Right. And I would have gone after the 6 points, or this, whatever the most popular NFPA says, how many departments out of the 28,500 or whatever there are departments are compliant with this? And his answer is going to be, I don't know. I've never surveyed them. So then how can you say that these are the most common, right? So, right. But they lost on the NFPA because to a jury of people, you have the standard, which everybody does, and you didn't. Right. But that's not true. So anyway, people should watch it. I guess we don't want to spend too much time on this, but great interview, brilliant lawyering, brilliant trial lawyering.
He really, really impressed me. His trial skills, they're superb.
So, I agree. I just don't agree.
We didn't rock him at all. None of our questions really rocked him at all, and it was kind of good. It was kind of like a meeting, like if we met him in a sports bar and we're just sitting at the bar talking.
Yeah, I agree. I mean, he did have one comment about me because I was, hammering him, needling him a little bit on some stuff.
He had you pegged. That's why he's a trial attorney. He can figure people out real quick.
But what you and I were most surprised about, I think, because your and I heads both shocked, right? Tilted when I said, well, didn't they object to proximate cause? Nope, never raised it. Didn't they object to the introduction of the NFPA standard? Nope, never, right? And didn't they present an expert? Nope, never did it. 3 things you and I absolutely would have done at a trial.
Yeah.
So,
not to beat up on that attorney either, because, we said one of the challenges that we're facing, you and I are both firefighters and attorneys. We've got 2 attorneys that are not firefighters arguing a case in front of a jury and a judge that are not firefighters.
Right.
So what you and I, what we just take for granted sometimes, these folks, they're not aware of.
But that's why you put on an expert, because otherwise the only
I know.
firefighter there is the plaintiff's expert. Anyway, okay, and brilliant lawyering. I don't agree with the outcome, but okay. Let's go to Utah. Talk about another screw up from a court, anyway.
Oh,
Right? So I guess I'll summarize the small issue. So there's a immunity statute.
Well, let's go back to the case, because I think this is
Okay.
one you and I did not cover this case earlier, and I think it's really unfortunate. I look back; it was decided in August. I looked at it, I put it in my database. It just wasn't one of the 5 cases I covered that week, but we've got a EMS unit from the Unified Fire, which is a big fire department in Utah, very very big, very credible, excellent. I know a number of the chiefs there, so it's a squared away fire department. They went on a medical run for whatever reason. They advised the person that they didn't need to go to the hospital. I am interested a little bit in the facts of this one too, because did they mark it down as refusal against medical advice when they actually told them you don't need to go? Because I think that's happening way too often, that people are telling people you don't need to go, but marking it as refusal against medical advice. So I know. But at any rate, bottom line is they go. They tell him it doesn't seem to be any problem. He was later hospitalized with a massive heart attack, suffered some permanent damage, and so now he's suing. And the trial court dismissed the case. So you have this person, George Armenta, sues the Unified Fire Authority. The trial court dismisses it because they have immunity. Now, this kind of goes back to what we talked about in the Illinois case, that no liability for negligence. Okay, so now the Utah Supreme Court, in its infinite wisdom, goes and looks at the immunity statute and says, "Yeah, not so fast." I'm sorry. Go ahead. You go ahead and take it.
No, you got it. You got it. I mean, so they look. We'll go into the statute. So it's Utah Code 63G-7201, and it includes firefighting and hazardous material incidents. It gives immunity for doing all these things, including, number 1, providing emergency medical assistance. But what the court says is, no, that's only in disaster relief, right? Mass disaster type incidents.
I don't see that. Do you see that?
I couldn't find it. I thought you omitted it, so I looked it up. It's not there. That language about some disaster type event is nowhere there. And they said the immunity was only meant for disasters because they compare it to other codes, 63G-7 something else. But they interpret it, I think it's called impari materia, right? You interpret it in line with how we interpret other statutes. What other statute? I didn't get it. In any event, they say that there's no immunity for going to a routine response. The legislature then was so outraged unanimously that, and I don't think it's law yet, right? I think that's going to the governor.
But they passed the House. It's going to go to the Senate, or it's in the process. So,
but they're correcting it. They're making it clear it applies to all routine events. I'm not aware of any other case ever like this. There's a lot of cases on how far does immunity go and what does it apply to. New York State just had a big one with regard to fire district motor vehicle liability. But I mean, there's a lot of these. But there's a lot of these statutes, but rarely, I've never seen one that only applies to disasters.
I don't understand. And, there are Supreme Court decisions that I disagree with and say, like, where did this come from? And this is one of them. I mean, what were they thinking? Whatever. They got off on that. Their trolley got on that track and they rode it to the end, and they ended up. It
may be. You and I have seen cases, all attorneys have seen cases where the court says this is a problem. We're going to interpret it this way, but we encourage the legislature to fix the problem.
Right.
But that wasn't one of the, I don't think in that decision they said we encourage the legislature to fix it. I think they just interpreted it that way. Anyway, so that was that. But okay, let's we're going to go to California. Before you say anything, I want to ask you a question because I think it's big. We have seen a number of these cases. Question before a court is right, because we have a group of former and present battalion chiefs. I want to emphasize battalion chiefs who, with the Contra Costa County Fire Protection District, they filed suit alleging that they're improperly categorized as exempt employees. Now, before we get into the facts here, I have a question for you. You and I have covered at least 3 lawsuits in the past 12 to 18 months where battalion chiefs were deemed non-exempt from overtime under the FLSA because they responded to scenes and that, right? And that they were on-scene incident commanders. And I think, this is my question, for that reason alone, right, they were, and maybe that's a stretch, but for that reason alone, they were deemed non-exempt. You go to scenes, you're right. And
but it's a little bit more complicated than that. It's a lot more complicated than that. And the metaphor I use when we're teaching this, and by the way, we've got our FLSA for fire departments class coming up in DeLand, Florida. So it's in 2 weeks, December.
The fire department may want to go.
Well, I think firefighters, attorneys, union reps. But folks who are concerned about overtime and how it's properly calculated and when people are entitled to it and all that go here. But one of the metaphors that I like to use, and I'm a baseball player, so I love baseball and it's my sport. Okay, so we think about the rules of baseball, and you have 9 innings, right? 9 innings. It doesn't matter if you're playing in Seattle or Miami or Boston or San Diego. It doesn't matter. You play 9 innings, okay? You get 3 outs, you get 3 strikes, and home team bats second, visiting team bats first. Those are the rules of baseball, okay? And then you have individual plays, and I like to use the metaphor of the close play at second base, where you have a runner on first, he's trying to steal second, and he's sliding into second, and now we've got an umpire that's got to make a judgment call, okay? And sometimes firefighters mistake that close play at second base for a rule that is, like, whether you're in Boston or Seattle, it's 9 innings. That's a rule, okay? Right. What's it got to do with battalion chiefs, okay? Each individual decision on each individual battalion chief is a close play at second base. And you can't say because one battalion chief was out that the next battalion chief that slides in the second base is going to be safe. It's not a hard and fast rule. So what we have here are judges. Maybe in the first instance, you have municipalities and fire chiefs making a decision. We think you're exempt, or we think you're not exempt, or whatever. And now it's being reviewed by a court. And it's not uncommon to see you're out, you're safe, you're out, you're safe, you're out, you're safe, until you run out of appeals.
Right.
Right. And also, like when somebody slides into second base, let's say they have an even number on their jersey. It's got nothing to do with the fact they had an even number on their jersey. Right? Or that they were in gray versus white. It had to do with that judgment call. And we look at all these other things. We say, oh, well, anybody with an even number is going to be out. No.
Right. No, so the balancing, not a balancing test, but the factors balance in the way of exempt, right? And the more you put on
you want the truth, Brad? You want the truth? I'm gonna give you the truth, okay? Yeah. If a judge is pro-management, they're not going to get overtime. And if the judge is pro-labor, they're going to get overtime. And it shouldn't come down to that. Absolutely, positively. But judges, lawyers are very intellectual people, and they find ways to craft their decision that meets their political and social beliefs.
Right. And there should be
it's as simple as that.
Right. And that's the problem. Like with the exempt tests, right? There's no one factor that's more than anyone else, says the Department of Labor. That weighs more than another. It's a balancing test, but and one factor may be a big deal in one, evaluation. It may not be a big deal in another. So these are all judgment calls, right?
We have cases that say a deputy chief that is on a shift is an hourly employee. We have cases that say a lieutenant on an engine company is exempt.
Wow.
And the Department of Labor tried to fix this with what they refer to as the first responder regulations. Came out, I believe, in 2004, the first responder regulations. And there are courts out there that go like this to it.
Wow. Okay. And that comes into play here.
Right. But what we do in the class is we try to walk chiefs and also battalion chiefs, but fire chiefs, city managers, finance people, we walk them through the criteria to put you in a better position. And the way I like to think about it is we're teaching you when you should steal and when you should not steal, when it's not a good idea here.
Not worth the risk.
This is some of the things you can do to make it more likely you'll be safe when you get to second base. Okay.
Right.
So we kind of walk and approach those things, because there are some things. So certainly the fact that they're on a shift and their primary responsibility is to respond to alarms takes it in one direction. But we've got courts, right? We've got courts to say, no, wait a minute, this person's also involved in budgeting. This person's also involved in administrative duties.
Great segue.
Right? So those are some of the factors. But
so here, with that perfect segue, what we have is in 2019, I think, the battalion chiefs were, as allegedly 80% of their duties, 20% was responding to calls, which to me is maybe 20%, but it weighs heavy. But 80%, yeah, and 80% was managerial administrative. They created a district chief position or a chief position, removed from all the battalion chiefs. This is what the lawsuit alleges. We don't know what the truth is, but they removed the managerial administrative functions from the battalion chiefs, and now their primary responsibility is responding to calls. So they say, you owe us 3 years. It's longer than that, but you can only go back with fraud, right? 3 years. And I don't know that this is fraud, but maybe it's bad faith.
It's just it's not fraud. It's intentional.
Intentional.
It's right. 2 years if it was accidental, and 3 years if it was intentional.
And this is intentional, right? I presume that's what they're arguing. They're arguing
intentional. You've got to show knowledge of what the law was and an intent to ignore it.
Right. So, who knows here? I guess, right, that'll be a fact. But, and so here they're saying, listen, we're now primarily first responders, hence the rule, and we don't do really any administrative or managerial. We should be paid overtime. And if the facts are as they say, they're probably right. But
as alleged, yeah, I would agree. Now, whether or not they're going to be able to prove their case factually, that'll be a different story. Yeah.
Right. And to me, I just, if you respond to calls, right, every day and it's not discretionary, you must go, versus discretionary, right? Discretionary would be a factor, but and they say it's non-discretionary here, I'm looking, you're more like a first responder. You may have managerial duties, but you're no different than a lieutenant.
One of the things we now, what we say in class and what we argue in court,
yeah.
Okay, is going to be different than whether or not that's going to win the case for you. But one of the arguments, so first of all, one of our attorneys that helps teach at Brian Massett likes to have the chief bring in their helmet. Okay, and if the helmet is perfectly white, that says one thing. Okay, and then he likes to say, I noticed that you switched from SUVs to pickup trucks. Why? Well, because we don't want the contaminated gear. Oh, so in other words, their gear is contaminated when they come back. So, but you're still saying they're white collar. So, making those kind of arguments, and then say, okay, what is the executive function that these people are doing at 2:00 in the morning? What exactly are they doing? They're sleeping. What is their executive, administrative, professional? And things of that nature, and he'll make those arguments. So again, there's a lot of strategic points that can be made one way or the other when it comes to particularly shift people. Now, if they're not on shift, that's a different story. But when they're on shift, and the example he also talks about, just is not so much in court, but just a way to think about it is you have a budget meeting. And you've got the fire chief, you've got maybe some administrative people, and you have somebody on shift, and there's a reported building fire. First alarm assignment goes out to a reported building fire. Anybody who's left in that room is an exempt employee. Okay, so if you're a battalion chief and you're dispatched on a building fire and you can stay at a budget meeting, you're probably,
right, agreed.
So,
listen, and I guess the last thing is people would become frustrated with you and I could see administrators watching say, so what choice am I supposed to make? And the answer is, listen, you do the risks. If it's kind of like this, frankly, I'm paying the overtime.
Well, and frankly, that's a conversation they need to have with Congress. Don't have it with us. I mean, we're not going to,
No, but I mean, as their attorneys,
the FLSA is an act of Congress, and if you think it needs to be changed, then take it to Congress. Just understand the IAFF in DC is going to be there telling people the opposite.
Right. But of course.
This is, again, it's like a lot of things, the FMLA and a lot of other laws. We didn't write it. You know,
Right.
we're just helping you understand so you can stay out of court because of it.
And sometimes helping you understand is educating you that it's not easy to understand, right? That the results are variable. You're the umpire at second. So, okay, let's go to Tennessee. I happen to agree with this. We have seen another case just like this about 2 years ago. This is definitely not the first.
Mhm.
We have Tennessee residents. I can sum this up pretty
No,
well.
this is Tallahassee, right?
Oh, Tallahassee. I'm sorry, Tallahassee.
Tallahassee. Yeah.
Jesus, I should put
Yeah,
on glasses.
we did have one, and I went back looking for it, and I couldn't find it,
It was
but we
about,
did.
I think it was about 2 years ago, maybe a
Yeah.
year ago. But
Yeah.
so in Tallahassee, we have the government imposing a service fee. Now, let's
Mhm.
talk about that. And it's been there since 99. Maybe that's where I'm getting my 99 in the other case from. But it's been there since 99. So the fire service fee, let's just talk about that term. It's for a service rendered, and typically it's on a per use basis. Typically, fire service fees, you used us, we're billing you. But they claim it's a tax. And a tax is only allowed if I'm betting in every state, though I can't premise, I can't say that for sure, but a state tax has to be allowed by the Constitution, and you cannot create a tax except in accordance with the state constitution. So they're arguing that this fire service fee is one, a tax and thus unconstitutional because it's not allowed. And two, and I like this argument, and two is actually has a racial bias, an unintended racial bias, and is thus discriminatory and void for that reason. And let me jump to that second one because that's really, brilliant points. They claim that the taxes disproportionately affect those who live in urban area in the city areas, and thus it's more low income and more minority populations, as opposed to the taxes lower in outside those areas. So they say it's a disproportionate tax, and you can't have that. Taxes have to be based on a formula without regard to anything except value, right? But it can't be related to race or where you live. Assessments could be, right? But that's a different issue. So that's their second argument. And the first one, as I stated, they just said it's not constitutional. I think they win. And if I recall correct, I don't know whether we looked at the result in that other case. I think it was just the claim in that case. I don't remember if it was
Yeah,
a
but I think,
result.
and I don't remember the details either, but I think that the distinction here is between a fee and a tax. Okay.
Yep.
And when you're charging a fee, it's okay. Like if you're gonna have a registration fee or a
Sure. It's for your
license,
use.
okay, it's for your use of something. Okay. A tax is different. Tax is applied to everyone. And here they're saying that this was an illegal tax. It was a fee it was posing as a
Everyone.
fee, but it was actually a tax. So that fascinating argument.
And look, they made one big point on that. You get it regardless of whether you use the department or not.
Mm,
That is a tax.
yeah.
It's not related to use.
Yeah.
So,
Well, it'll be interesting also to see how does the fire department, in the event that they prevail, that the plaintiffs in this case prevail. Now, what does the fire department do for income?
yeah.
Now you've got this other big concern. So
Get it approved as a tax. They just took a short shrift, and
yeah.
it's not like district taxing and all that is foreign. I mean, it may be there, but it's not in any other state. So, okay. So this one, let's pass it back to you. If we
Yeah.
could talk about going to Boston.
Yeah, I went to school in Boston, went to law school in Boston, and then took the EFO executive program at Harvard. So I've spent and worked for the NFPA for a couple of years. So I've spent my fair time in Massachusetts.
I
And
worked EMS in Boston for 4 years.
there you go. So in some respects, it's a wonderful state. In other respects, it's incredibly bureaucratic. And your state is too. New York is your old state.
Thank God. Thank God. Yeah, my former.
Yeah. So,
state.
yeah, you got out just in time. But but at any rate, they have a statewide civil service system. And I've talked to a number of chiefs in Massachusetts, and it drives them crazy because they try to discipline somebody. They appeal it not to a local civil service. They go to the state, and then a year and a half later, they get some sort of a decision. And in the meantime, the guy's in limbo. Then they got to pay him 18 months of back wages and everything. And it's a mess. But bottom line is the state civil service system controls a lot of the hiring, firing, discipline, promotion process in the state of Massachusetts. Even though we're talking about the Boston Fire Department, the Mass Civil Service controls a lot of it, including the hiring. And there traditionally has been a veteran hiring process that's recognized in Boston and also recognized, in the state. Boston, apparently, from what I understand, has done exactly what I believe many communities do. I know Providence did it. They attempted it. They created a cadet program in the local high schools to try to increase diversity within the ranks. And what they're trying to do is get into the schools, get folks interested in police and fire, EMS,
Laudable goal.
provide classes and provide a little bit of mentorship at a young age, and maybe keep people out of trouble, number one, and then get them so that they're going to be at a point where they'll be able to apply and then become firefighters, police officers, paramedics, etc. So wonderful idea, great idea. Hasn't always lived up to the expectations of it, but sort of the cherry at the end of this is that you're going to have a little bit of a preference for when you completed the program and you're ready to be hired. So that was the goal. Now, apparently, from the allegations here, and that's all we're going on, is that the city created this program, but they didn't get it approved through the Civil Service Commission, and they hired some of these people. And basically caused the folks who were legitimately in the state civil service system's priority list because they were disabled veterans, caused them to get passed over. And so it's more a technical error on the city's part that they're alleging that they didn't get it approved by the civil service system. So I think that's really the nature of the allegations. They're not, I don't think, alleging any sort of discrimination, but they're just saying you didn't follow the proper process to get your system, your cadet program system approved. Therefore, you violated state law by giving these people preference to us.
And one of the things the lawyer does, which I like, this is more like a lawyer tactics discussion, but the lawyer goes a little bit off topic and says, look how poorly the system is working. They have a higher failure rate than ever before, right? They're kind of lambasting the system, but they do that to plant a seed in the judge's mind to say, I've got a violation, but I've got a good reason too. We're trying to increase diversity, get people in, but then to throw in, okay, it's not working. You have a high failure rate. Now a judge would think, yeah, you're right. Let's do the right thing. And the point of that is no different than you talk about your second base umpire and all that. People can, or if you're a biased one way towards management or against management, right? Judges can almost craft any decision as they want, depending on their bias. So saying that the system doesn't work would be very important. For example, if you end up with a minority judge who's not a veteran, they may have their own internal bias against this. So what they do is they paint the factual picture. It ain't working. And I think that was a smart move why people do that. And it's, again, another kudos to a lawyer. They haven't won anything. They just made the allegation. But I like the way they couched the complaint and drafted the complaint. Okay, well, I can't believe we're going to cover this for this.
We covered it before. We covered it before, and it's one of those cases that doesn't seem like it's going to go away.
Wait, so we're in New Jersey for everybody. We have a $25 million lawsuit over yet again another noose incident. Yet again. Okay, if you're a firefighter and you're watching this, now probably this is going to fly over you because if you're watching this, you're probably not this type of person. You do not tie a noose at all. There's no noose knot that's ever it's not a figure eight. It's nothing in our rope rescue. I'm a rope rescue guy. There's no use to a noose. And you sure as hell don't portray it or hang it or hand it to or whatever in front of any black male or female, period, or at all. You just don't tie it. So yet again, another noose case. We're in Bloomfield, New Jersey, and we here are the facts, right? We've got a firefighter who's black. There's already an allegation. There's allegations. Again, this is just a lawsuit. We don't know, but apparently there is. And they say this on information and belief, which is not helpful because it means I've never heard it. But they claim that an individual has constantly used the N-word in the presence of black members. By the way, I want to point something out. I've said this before. I'm going to say it again because, the lawsuit talks about African American, and I say black. And everyone always asks me, I've had people say, why do you say black, not African American? And it's because one of the fire departments I represent, North Amityville Fire Department, is about 95% black. And one of the guys who was at my conference, I was trying to be very good. I said, African American. He said, you offend me with that. I said, I do? He said, I'm not African. He says, in fact, I'm European. He's like, but I am black. He said, African-American is a subset of us. He said, we didn't all come from Africa, and it's a little insensitive to say that. I'm like, Jesus, I can't keep this straight. So I say black. So if anybody's offended, don't be, because I consider myself now better educated by.
I've been told that saying black is offensive. So.
Right. And then we're so far off base, but then people of color, that's okay to say, but you would never say colored.
Yeah.
It's very difficult. You do your best. Right. You do your best. In any event, so he allegedly, upon information and beliefs, this person has made these derogatory N-word comments. That's never appropriate. But then he, and was never disciplined. But then the big issue is this guy ties a noose, the same individual ties a noose and hands it to the black male saying, Thomas, there's a noose upstairs on the table. Did you see it? Right. So I guess he talks about it and I hands it to him. And then the plaintiff, the guy suing, says, why would I want to see it? And it just goes on. So, but nothing happens. It gets reported, no investigation, no discipline. Now, I got to tell you, if somebody tied a noose and left it on a table upstairs, A, it should be removed immediately. B, if they know who did it, should be disciplined. There's no reason to tie a noose and leave it up there. But here's going to be the issue. This may all be true. Mm-hmm. And the person might just be saying, listen, there's something offensive up there. I just want to know whether you saw it or not, right? These facts could play both ways.
Well, it didn't. The perpetrator was charged criminally with a hate crime.
Right. Okay? But that wasn't, if I'm correct, that wasn't the person who asked if you've seen it.
Yeah.
Oh, was the person who tied it the person who saw it?
Yeah.
Okay. Yeah. That's the part I missed.
And this guy's got a history of behaving in a racially offensive and intimidating way.
Yeah, but I didn't see that he actually tied the noose himself. He said that they were.
Oh, I see what he's saying. Yeah, I thought, well, I mean, certainly the allegations seemed to be that he was responsible for it. And again, he was charged with it's called fourth degree bias intimidation under New Jersey law. And he went into some sort of a pretrial diversion.
Oh, no, I see it. It's near the bottom. It does say it. As the training was concluding, the individual coffee tied a hangman's noose and threw it towards plaintiff. This is a separate incident. Towards plaintiff, laughing and smiling. I want to figure out, what kind of knot this is. Okay, so that's the part. It wasn't that it was, maybe there's two incidents.
There was two incidents, yeah.
Okay, there you go. So one is, hey,
they apparently didn't do anything after the first one, and then after the second one, then they started an investigation, but then it got turned over to the police and the prosecutor to investigate.
And you start getting excuses from, because I've heard these, being Jewish, I've heard these, they're like, oh, I thought it was funny. I thought you'd appreciate it. We're just a humor. I lecture about this. It wasn't one of the cases we talked about, but it was one, but it was a news story. Maybe I'm sure it's in your database, but somebody, they got their first black recruit or firefighter. They've never had a black member of their department. So what they do, and their career department, they tied a noose, put a black or brown teddy bear in the noose, hung it to the guy's bunk, and left it there. And they all admitted they did it. They said, oh, we're just trying to show you that it's okay, you're black, we don't care. That type of mentality, right. I have the news article, but that type of mentality.
Well, I mean, is it sincere, or is it a cover story? Because
I think in that case, they were sincerely ignorant.
Yeah. Yeah.
Um,
I mean, good Lord.
I don't know. It's like drawing a swastika on my, whatever, and
Yeah,
saying, "Oh, we
really. Yeah,
saw you."
welcome. We want to welcome you to welcome to our law firm, and then your door has a SWAT sticker on it. You got to be kidding me.
Yeah,
It's not a
yeah.
welcome.
Although the first law firm I walked into, I worked at, I thought I was going to stay. That senior partner says, "I'm not building this firm for that Jew Pinsky." I didn't go over well. In any event, but I think that is it was in Louisiana, so you could see that. But
I had a captain pull me aside one day, and he was just talking about the department. And again, he said, you know what the problem with our department is? There's too many chiefs with a vowel as their last letter in their
oh,
name. And then he
oof.
thought about it. He says, "What's Verone?" I said, "I'm Italian."
Yeah, it's a silent E. The silent E.
Yeah,
Uh,
right.
Jesus. Anyway, so that
Yeah, so
look,
there's a lot, and whatever.
if anyone
People,
doesn't realize there are going to be repercussions for your actions or inactions, you're going to be disciplined at best. If you're the employer and you don't discipline, you're going to be sued at worst. And if you're the person who did it, you could be arrested, you could be sued, you could be both. You're going to be fired, you're going to be ostracized in your community. Don't do this stupid stuff. I, anyway, that's our week. This
those,
was a great show.
yeah.
Great week.
It was a lot of stuff, some of which, we're not going to give clear answers to I think one of the biggest
FLSA, yeah.
challenges in the FLSA is that executive exemption for line chiefs. Administrative chiefs, that's pretty clear. Company officers should be clear, although we've got a case, one like outlier case that says company officers are exempt, but for the most part. But the line chiefs is it's a tough issue. But again, we'll be talking about that in DeLand, Florida, December 9th to 11th, and then we're going to be in Houston in February too.
Where
So
in Florida? I'm going to look up where that is. Is it close
DeLand,
to me?
DeLand, Florida, just it's about a half hour north of Orlando.
Oh, I
North
may
and
attend.
on the West Coast. So
I
you're
may
certainly
attend.
welcome. We'll hook you up. We might have you teach a little bit if you show up. So
God forbid.
that's
So
okay.
but and the last point to your, thing, the NFPA, everyone always says, what's the value of NFPA in court? Does it matter? Does it not? Well, you just got one good example why you got to address it in some way in your policies.
Yeah.
Got to address it.
You can't
So
you can't ignore it.
it
You
will
don't have to
bite
be
you.
100% compliant. Nobody's saying you got to be 100% compliant. Nobody is 100% compliant, but you can't ignore it. So, all
Okay.
right, man. That's
Happy
it.
Thanksgiving to everybody.
Yeah, happy Thanksgiving to you, Brad, and happy Thanksgiving to all our listeners, and we'll see you again next week.
Take care.